Welcome to the lesson on the right to refuse to work. As usual, learning materials can be found in the description below the video. Under UK law, employees have strong legal protections against unsafe work environments and employer retaliation. Section 44 of the Employment Rights Act 1996 gives employees the right not to suffer detriment, for example, disciplinary action or dismissal, for refusing unsafe work, provided they have at least 2 years of service. Employers are liable not only for harmful actions but also for deliberate omissions. They are under a duty to actively protect their employees from unsafe working environments. Section 2-1 of the Health and Safety at Work Act 1974 further mandates that employers ensure their employees' health and safety as far as reasonably practicable. Furthermore, the Health and Safety at Work Regulations Act 1974 places employers under a duty to perform a risk assessment of the work environment and act accordingly. As observed by Moore, employees may be entitled to a compensation if they were subjected to any disciplinary action, including loss of pay and/or dismissal for refusing to return to an unsafe working place. Employees must have worked for the same employer for at least the last 2 years in order to benefit from this entitlement. These protections are strongest for employees, less so for workers, and minimal for self-employed contractors. Section 230(1) of the Employment Rights Act 1996 defines employees by having a contract of employment and enjoy full rights, including protection from dismissal and unsafe conditions. Workers, who work personally but not under a traditional employment contract, are defined in Section 296 of the Trade Union and Labour Relations Consolidation Act 1992 as having some rights like minimum wage and non-discrimination, but fewer health and safety protections. Self-employed contractors have the least protection and are generally not covered by employment legislation, though clients must still ensure safe premises. Remember that because legal categories aren't always clear-cut, courts apply multiple tests, for example, control, integration, mutuality of obligation, economic reality, to assess employment status, as seen in cases like Uber versus Aslam and ready-mixed concrete. In conclusion, UK law prioritizes the protection of employees due to their reduced autonomy and greater dependence on their employer, especially concerning health and safety risks. While workers receive limited safeguards, self-employed individuals must largely rely on contract terms or claims of wrongful dismissal. This suggests that English law treats the right to refuse to work rather restrictively and makes it subject to the employment status of the worker.